the entire argument on the part of the petitioners council as of now is that what Mr. Pramod or Senakumar they are saying, you don't fix the minimum marks or qualifying marks in the notification, sense that you can't now fix the 40%, 35 and 30% to the home guards category. Also, that's what they're saying. That's what, sir?
Yes, Lordships are right.
You can't fix the same marks.
Yes,
And you got to fix a separate mark to them.
yes.
We cannot be treated at par with either OC, SC or BC. We should
In
be
general
treated
recruitment,
in
not
general-
general recruitment.
in general.
That's what. You have to fix it.
It should be the same exam. Can be the same exam.
Yes.
However, the marking should be different. The cutoff mark should be different.
Yes.
That's what they're
That are applied
Qualifying
to.
marks.
That's what precisely case is that. Same
Non-home
exam is
guards.
one and the same. Exam is one and the same. But that 40% for OC, let's say general recruitment, that 40, 35 and 30 is for general recruitment. But it being a special category, you can't pick the same matchstick to them also. You got to fix 30% or let us say, for some part, whatever it means, it is to the it's a government because we have to ultimately it is your decision, you are the decision maker. We can't, that's what.
The
Yes, yes,
Supreme Court also said that the reservation related to a special category will remain illusory if they are not given a special relaxation.
Which in the Daria's case,
Yesterday I
He
read
has read- he has read
along
the
with
judgment to Lordships
along with
also.
synopsis I have filed.
That is the case, the Millard Muhammad Yunus case.
yes, yes.
1999,
Yes.
ex-servicemen. Ex-servicemen, Millard are home guard. Stand in the same
By
footing.
virtue of the
special category.
amendment, by virtue of the amendment in para 32 of the 37 of the counter, they said that we brought under on par with the ex-servicemen, special category. Therefore,
one by one, it's easy to me so that I
Yes,
can
yes,
also pose questions. To
Lordship kindly see the judgment, Millard.
Yes, yes, that's
Along
what.
with synopsis.
Yes, yes. One line where the fixation of general standard marks prescribed for general candidates.
Para 3, yes.
Undoubtedly
Yes, yes.
handicap.
And
That's what you are saying.
Yes, yes,
the number of candidates available are also less than the post Millard that is notified for the Millard, the home guards.
Yes.
Another judgment also I have given, Millard.
What is the other judgment, sir?
Suresh Kumar, Lalit Kumar Patil yesterday. Live law judgment.
Yes, sir. Live law.
That is also Millard paras.
Para 31, 32.
Yes, ma'am.
Into.
Yes, ma'am. There the Honorable Apex Court said that Millard they can, government has power, recruitment board also.
Yes, sir.
Millard, if by doing so, the government is not going to lose anything, Millard, because if we are disqualified, the general candidate will be appointed. If we disqualified, the general candidate will occupy those vacancies which is meant for us. And if the earlier Millard judgments are implemented and it is followed, we will get, because we are serving the department for the 10 years, 11 years in orderly work, Millard, that if they are saying it is very difficult to hear also, such a work they are extracting from them.
Yes, sir.
Millard, Since there is no policy, if this is implemented, the government policy will not be any disturbed. Like instead of this, they would have gone for a limited recruitment for these 1100 vacancies.
But we can't.
Because I am suggesting the
Yes.
special GP is here.
Yes, sir. Yes, sir. Yes, Mr.
The very purpose of creating a special category.
Yes.
That will be.
Please take
Everything-
your seat. Please take your seat. Yes, that's all. Yes, sir. You want to say something?
Yes, Your Lordship.
Yes. What is that you are saying?
Petition number 10286, Your Lordship.
Yes, sir. You are
That's in the present date petition are slightly different, Your Lordship.
10
286 of 23, Your Lordship.
1028.
6, Your Lordship. There are 4 writ petitions in the present writ petition, Your Lordship.
10286 of
23, Your Lordship.
and what are the four, sir? Please give those numbers. You filed all four?
Oh, yes, Your Lordship. All the 4 petitions are there in the present.
Oh, four petitioners.
Yes, Your Lordship.
Good name, sir?
From Hari Krishna, Your Lordship.
Yes.
Out of 4 writ petitions, Your Lordship, 3 writ
Four,
petitions.
four petitioners or four writ petitions?
4 writ petitioners, sir.
Writ petitioners. Yes, sir.
Out of 4 petitioners, Your Lordship,
Yes.
the first 3 petitioners have been qualified even after applying horizontal reservation, Your Lordship. 4th writ petitioner has been disqualified, Your Lordship.
What is you are qualified? You secured minimum marks?
Yes, Your Lordship.
40%, 30%?
Yes, Your Lordship.
Yes.
But they are being denied, Your Lordship. On the ground that they are overage, on the ground that they are not local, by virtue of their working station in Telangana, Your Lordship.
Oh, that's a separate. Sir, that's one.
In my case, 6631 also, the petitioners not working in Telangana, they are appointed before bifurcation.
WP 66?
66, the first case, but what you were last.
Yes.
6631. First case,
Yes.
and one more case, is also there. I will give you the information. 4 petitioners in other case.
So there is separate category now. Those persons who have not been rendering service in Telangana.
Local candidate will apply or not. It is for the government to apply because we are appointed prior to bifurcation. After in the reorganization act, these temporary services they are not mentioned how they are should be
Yes.
transferred or apportioned or granted. In view of silence on the aspect of the reorganization act, they are continued in the Telangana region only. But they are, for all purposes, they are local to AP. They study as permanent residents as per para 7 of the presidential order. Condition is that they should be working in the state. That is coming in our way.
One 10286.
For all purposes, because their domicile is from, they born, brought up, everything is here. You have to treat it as, and in the notification, what is this in the notification?
They should be working in the AP state.
The notification is specifically mentioned? Where is that, sir, notification?
Challenge it.
You have to challenge that, saying that, where is the notification, sir? Notification, where is that?
Page 23, Lordship, of my writ petition, Lordship.
Which clause, sir, in notification?
Lordship.
Clause number 13?
Yes, sir.
Eligibility candidates, conditions?
Yes, Lordship.
Yes, sir.
May I proceed with
Yes, please.
Yes, Lordship. As far as age relaxation is concerned, Lordship, may I invite your Lordship attention to page number 24B, your Lordship.
So on both counts you are denied, sir, age and
Non-local.
non-local.
Age relaxation, Lordship. The upper age limit prescribed in para 13BA above will be relaxed.
Which
as
class, sir? Clause number?
BA, Lordship.
Clause number. Which class?
13 capital B. In that capital B, Lordship, small b, Lordship.
Small b, sir. Yes,
Age
sir.
relaxation.
Yes.
prescribed in para 13BA above will be relaxed as under your lordship.
Yes, sir.
That your lordship, up to a maximum of 5 years if a candidate belongs to EWS lordship. Then, up to a maximum of 5 years if a candidate belongs to backward class or a scheduled caste or a scheduled tribe lordship. In the present case, your lordship, the petitioners belong to both backward caste as well as scheduled caste, your lordship.
What is the sir, age prescribed here? In the
32 is the maximum age limit prescribed for home guards, your lordship.
where is it, sir?
Next page.
My lords, in the
13A, my lord. 13A,
in the 13 capital B, small a, first thing.
Yes, any person, a person who is local to Andhra Pradesh.
A
That is
person
Roman
who is
one.
local to Andhra Pradesh state, also working in Andhra Pradesh Police Department as on the date of notification, has been on duty as home guard for a minimum duration of 360 days within a period of 2 years, and who is still continuing his service as home guard must have attained the age of 18 years and must have attained the age of 32 years.
Must not.
Must not have attained the age of 32 years as on 1st July 2022, must have been born not earlier than 2nd July 1990 and not later than 1st July 2004.
Yes, sir. Then relaxation is 5 years.
Relaxation in class B, lordship.
Yes, sir.
5 years relaxation has been prescribed, lordship.
For EWS.
For EWS as well as backward class and scheduled caste and scheduled
Yes, sir.
tribes.
5 years, sir. Yes, sir.
Small b.
Yes, sir.
2
Yes,
years.
sir. Yes, sir. Yes.
May I invite your lordship into page number 168, your lordship.
Yes.
168, your lordship.
Yes, sir. 168, sir.
Yes, sir. This is notification of 2016, your lordship. In the notification itself also, your lordship, the same has been prescribed, your lordship.
Yes, sir.
The same has been followed in 2022 also, your lordship.
There is 30 years, sir. Now it's 32.
Yes, your lordship. Slightly very, your lordship. But my lords may kindly see, your lordship, page number 169, as far as B, top, your lordship, age relaxation.
Yes, sir.
Clause 1, your lordship, for the post code number 2122, below that, your lordship, the upper age limit prescribed in para 10BA, 1 clause 2, your lordship. In that notification, your lordship, they have exempted a certain clause, your lordship. But in this notification, lordship, they have clearly
Sir, have you challenged this notification on that ground before participating, before your making application?
My lords, only after writing the examination, lordship, they came to know that they are being denied on this ground, lordship, because the judgment of this Honorable High Court touches the very root, lordship, the notification itself, lordship.
Which judgment, sir? Sir, as per the notification issued by the authorities, the prescribed age limit also, that one should not exceed 32 years, and the relaxation is for 5 years for EWS, SC, ST, and BC. Probably that the relaxation is there.
Now that they have
And
come to
petitioners
know
with
only
eyes wide open participated in the examination, though he is not eligible. Then he was declared as not eligible because of the notification. He didn't challenge the clause in the notification before you are making application.
But my lords, the clause in the notification itself says that 5 years is the relaxation.
Yes, that's what. Yes.
But only in the count they stated that you are overage, we don't consider. No, on one ground they say that you are not treated as home guard, lordship. On the other ground they say that we apply horizontal reservation and prescribe the same marks, lordship.
We'll one by one.
But
Let us not. Mr.
They are appropriate.
Krishna, no problem. See, now we are saying about age. Then we'll go to the other one, horizontal. Age is concerned, they prescribed in the notification. We didn't challenge that. And now the petitioner is, what is the petitioner says here?
32, all are above 32, lordship. They have given it in their counter, lordship.
You are 34, and you belong to OC category?
BC and SC.
If BC and SC, then you are eligible.
Yes, lordship. But they are denying.
That 32 plus that relaxation is counted, we are eligible.
Yes.
In my case also, we are at 32, 33.
Yes.
18 to 32 plus this B2 relaxation
Plus
is
5 years.
extended. 5 years, that has to be extended, added.
They are treating it in the alternative, Lordship.
What is alternative?
Either you take 32, not 37. Like that, they are treating it, Lordship.
What is that, please?
32 plus 5 years, 37, Lordship. Plus age relaxation, 5 years, Lordship. And category is considered, Lordship. The
For
maximum-
everybody according to you, or only for this class of category only?
For each class as prescribed in the age relaxation clause, Lordship.
Sir,
For home guards, 32 is the maximum age limit prescribed, Lordship.
yes, sir.
And in the next clause itself, they have prescribed that as we prescribed in clause 1, now this is relaxation clause, 5 years as per the category, Lordship. Communal category. For
Yes,
BC, 5 years.
communal only, BC, SC and ST, that's
Yes, sir. Now
Yes.
that the petitioners fall under communal category also, Lordship, 3 petitioners belong to BC, and 1 petitioner belong to SC.
Yes.
Now they claim that we have to be given that relaxation age also. 32 plus 5, 37. Now we can't be disqualified on that ground.
Where is that? They said you are disqualified because you are 34-year-old. Where did he say that?
But my lords, only because this relaxation is there, my lords, they have applied. But in the counter, they say that we don't give because you are overage. Now that they have come to know that they are being denied on the ground of overage, lords.
Above 30, above 32,
Yes, lords.
below 37.
Yes, lords.
So they are entitled to.
Yes, lords.
Oh, that is one aspect. Yes, sir. So for these 4, yes.
Sorry for interruption.
Chepandi.
What grasp from him. If suppose if 32, 37, if that is calculated, they will treating him as general candidate, not as a candidate of home guards quota.
Oh, not special category.
Yes.
In one aspect, they are treating, in one case, they are treating like that, your lordship. In my case, they said that we will qualify you as by prescribing mark, by taking marks into consideration as prescribed for BC, OC, ST, but we don't give that relaxation because you are asking under home guard. They deny your right because we claim it under home guard. They also deny your right because they don't treat it as a general category because you are claiming it under home guard. That is the problem here itself.
So according to you, that this age relaxation, according to the government, this one applicable only to the general category, but not the special category.
Is their claim, your lordship.
That's what they are saying, and the counter is saying.
Yes, Lordship.
According to you. Otherwise, you are also eligible.
But in the clause itself, there is relaxation, your lordship. There is no such rider, your lordship. That we are treating it only for special category. This relaxation is not eligible for special category candidates. There is no such clause in the notification, lordship, as far as age relaxation is considered.
Yes.
Even one should get.
Then what is that other thing you are saying? What is that horizontal reservation? What is that you are saying?
Yes, lordship. As far as treating home guards category is concerned, lordship, I adopt the arguments of land senior council, lordship. But the other ground that on which they are denying our right to participate in the further process of selection, lordship, is non-local, lordship. They are because after bifurcation, lordship, they are not allowed to come to Andhra Pradesh, lordship, because of they are constrained to work in Telangana, lordship. By virtue of their working station, and by saying that you are not working in the state of Andhra Pradesh, we deny your right to participate in the further process of selection because you are not working in the state of Andhra Pradesh and working in the state of Telangana, lordship. As far as the definition clause interpretation is considered, lordship, Honorable bench of this High Court has clearly interpreted, lordship. May I invite your lordship's attention to page number.
Local, non-local
Yes, lordship.
is 203.
Yes, lordship. As far as local status is considered, lordship, they are not having residence in Telangana, lordship. They are having the permanent residence in Andhra Pradesh. Only by virtue of their working station, they are in Telangana. They consider them as local by virtue of their birth or residence here, lordship. But they say because they are working in state of Telangana, they are not locals. And then Telangana, the state of Telangana is also doing the same, lordship. You are not born here, so you are not local here. You go to your own state. They say that you are not working here. You go to Telangana. Where do they go, lordship? That's the plight, they are also throwing their fate into the lamentable state of affairs, lordship.
Yes, sir. Now, all these 4 petitioners, they were denied on both counts. Age and
First 3 petitioners, lordship, as far as first 3 petitioners will consider, lordship, they have qualified, lordship, even after applying horizontal reservation. Though they claim to be treated as separate category under home guards quota, But they treat them as horizontal reservation, Your Lordship.
What is horizontal reservation again?
My Lords, we are claiming it under Home Guards quota, Your Lordship.
Yes.
But they, by applying the quota prescribed under OC, BC, ST, though by not applying, prescribing separate cutoff marks for Home Guards, Your Lordship, despite not treating them, not creating a separate merit list or not prescribing separate cutoff marks for Home Guards, they are qualified, Your Lordship. Because they treat them on normal general category, general rule, Your Lordship.
Yes. Because they are working in Telangana.
Yes, Your Lordship. Only on that ground, Your Lordship, they have been disqualified.
Though they are qualified.
But the fourth petitioner is not qualified, Your Lordship. Even for in the first exam, Your Lordship.
Oh.
The first stage of exam, Your Lordship. But because all claim to be treated as separate category, requiring separate cutoff marks for the purpose of selection, all the petitions have been added in the present writ petition as writ petitioners, Your Lordship. But the first three petitioners have been qualified, even though they have applied horizontal reservation as they prescribe or as they claim, Your Lordship. But as far as the fourth petitioner is considered, he has been disqualified as they apply the same reservation for the all Home Guards, Your Lordship. But two classes have been created because of the qualification and
Non-local mean, yes, sir.
yes, Your Lordship. So one on the ground of as a Lordship,
Yes.
they have been disqualified.
Yes.
On the other ground, non-local Lordship. They treat them as locals by virtue of their residence or birth, Lordship. And on the other ground, because they are working in state of Telangana, they don't treat them as local.
Yes.
They approbate and reprobate, Lordship. They say that because we are claiming that rules of the game can't be changed in the middle, they say that if we allot the post to the Home Guards, as they claim that they shall be treated as separate category, we are approbating and reprobating. By doing so, we are changing the rules of the game. They are saying that in that counter.
We'll see, sir. Yes. That's the difference between the other one and this one. Yes. Yes, sir. Yes, Mr. Srinivas.
Lordship, adding to the other petitioner's arguments,
Yes, sir.
my repetition item number 36 may be taken up.
Yes, sir. What is your ground?
Page number 21.
What is your ground?
Lordship, my submission is the 15% quota and 25% quota as it is may totally count 1100, more than 1100 posts vacancies
Yes.
in the specific category.
Yes.
Now, after examination, preliminary examination, applying the rule, cutoff rule for everyone, including these petitioners, the only candidate selected is 150.
Yes, sir.
So my submission is, this is a special category wherein the nature of the duties performed by the Home Guards 24 hours into 7. So my submission before this honorable court is, the special categories are marked for special reasons. That special reason is that, Your Lordship, they are working altogether 24 hours duty. They don't have any working hours altogether. They are working altogether 24 hours. So my submission is, having chance to appear and to prepare for the examination is also a scapegoat. That is one part. The second point for consideration of this honorable court is, Your Lordship, kindly see the Rule 22, wherein Honorable Division Bench also held that this is a special category wherein to be treated all these candidates. If special cutoff mark is taken into consideration or merit is taken into consideration for all these candidates, nothing happened. Your Lordship, kindly see the counter filed by the respondent state also. They are saying that vertical and horizontal, this will be disturbed. This will not at all be disturbed. Why? Because if they comes under the category of open category by touching the open candidates, Your Lordship, that may be disturbed. But whereas in the special category earmarked for Home Guards only 15% quota and 25% quota, that is only exclusive for their quota. As Your Lordship pointed out in Rule 7 of the notification, wherein if they don't select, they don't have any eligibility criteria, then all the posts will be earmarked for open category. Then grave injustice would be caused to the petitioners here in a special circumstance. Your Lordship, kindly see, reservation under Article 16 is earmarked for what purpose? Basing on their social category, economic category, social status, and all these things. So also in this category of this Home Guards, the special category was earmarked for nature of duties they are performing. So considering all these relevant facts, Your Lordship, kindly see, I specifically pleaded in my pleadings also that the honorable court, honorable division bench of this court in between chairman state level police recruitment board and others versus B. Samsel. I specifically mentioned in my pleadings also. When this exclusion of rule 22, considering the situation as on fact, as on ground. So
this is Samuel judgment. This is Samuel judgment you are referring to.
Yes.
Just now, yeah, that's no problem.
So
yes.
my submission before this honorable court is these specific posts are earmarked for home guards for so and so posts. If they are turned to be the open category posts, grave injustice would be caused. Balance of convenience and irreparable loss would be caused to. Why? Because if these posts are not carry forward posts. If carry forward posts, they are having ample opportunity to appear in another time.
That's what answer. Same thing.
So,
yes.
So my submission before this honorable court is prescribing qualification cutoff marks on par with other OC. And if they are competing with open category, then they may do so. Yes. But they are not competing for open posts. They are competing for specific posts earmarked for their reservation. So that can be preserved by this honorable court wisdom, your lordship, by considering the fact of the case and as well as nature of performance of the this.
Why did you not challenge that clause, sir? Why did you not challenge that clause before your?
There is no such. Your lordship, my submission is as already pointed out by my learned brother.
That's what I've been asking everybody. See, you don't challenge that, and so after you are disqualified, everybody is challenging that, saying that it's something contrary, because you're special category. They could not have. They could have issued some. They could have put some marks in that. We'll see that.
My submission is to the query posed by this honorable court. If the notification specifies certain clause, I would have an opportunity to challenge this. Yes. The notification does not prescribe, so then I don't have an ample opportunity to challenge the same. If they do so, then I'm having opportunity. That's my submission.
So anybody from petitioner side? Yes, Mr. Srinivas. Anybody from petitioner side, or I'll hear the state now. So because now they covered almost every point now.
The point is that as per rule 22 is concerned provides special category provision.
That's what.
Because of that, even though there is a special provision, but they have not mentioning the cutoff marks with regard to the special category. Though mentioned in ex-serviceman quota, but not mentioned in the home guard quota in the notification itself.
The notification, what is that, Anjelu? You're saying?
There is
marks were prescribed for OCBC, all these things.
All these things.
Yes.
But not mentioned it with regard to the special category quota,
yes.
home guards.
Yes. Yes. Then we have to try adverse inference.
Not because of that, we're losing our rights.
That's not said, because they don't mention that in the notification in the note of D. That is what is the impact of it?
Impact that we are losing, we are not aware about the cutoff marks.
Not mentioning it will whether it inure to your benefit.
Yes, That's why in case they are mentioning any marks with regard to the home guard quota, then we realize we get that. Without mentioning that, we can have no knowledge about that subsequently.
That's what. Yes, anything.
But subsequently, they are treating as that we are unable to say.
Yes.
That's the only thing. The other
yes.
Yes. Also the counter silent with regard to the orders passed by the administrative tribunal and confirmed by the.
We'll see that.
That was kept silent.
Yes, sir. Yes, madam.
Number 5 and 11, my lord.
Your lordship.
And for the council of representing Mr. Shivaram, my lord.
Yes, sir.
He's on legs before.
Same thing, sir. You want to improve anything more?
You want to add? The council, you want to add something?
Yes, madam. You are not there? Yes. Probably then we'll subject what's I think you can come probably after lunch.
A request for Monday because learned AG is appearing in this matter. So
Madam, you are there because I
or
said.
at least tomorrow.
Tomorrow again I have to see. That's what in fact indicating. I disturbed every work here. Now that you have noted down, you have to answer these things. Now, non-mentioning of marks in the notification is one thing. Reservation, I don't think it will take a. What is it? Whether that mentioning of reservation is it taking away their right?
No. In fact, they are being given separate posts. what their grievance is that those posts vacant.
No, because of qualification. See, but for this 40%, 35%, the 30%, if you, for example, had you fixed 30%, they would have been participated and you would have selected out of who secured 30%. Then you will apply other things there.
Even then, they want a separate merit list for themselves.
That's what. A separate merit list for themselves by fixing some
And
qualification.
not just the qualification.
Qualification,
It's
this is
not just
the
about
marks.
the cutoff marks.
Cut off mark.
It's about treating them as a separate category in the sense their benefits, their everything would be separate with a separate merit list.
That's what the then
So it's
earlier
as good as having a separate recruitment for them.
a special category which has been in the earlier OER conference division bench said their special category you can't equate with the other general category. That's what so far. And even Supreme Court said you could have supposed to treat them separately only. Then you could have fixed some marks, or you have to select merit out of them. The persons participated, some may get 20, some may get 50, then you have to go for that. Then in that again you have to follow reservation. That's what they are saying. Some may get 70, some may get 60, some may get 40. You have to prepare a list, then you have to follow reservation. That's what their contention is.
Yes, Miller, that was mentioned in the notification. We will write
And
it.
so far this Telangana aspect is concerned, judgment Justice Ram Subramaniam, where his lordship said, because what immediately is not there. Persons who are there in AP for 360, they are eligible. That's what they are saying.
I'll answer your question.
More disturb AP పెట్టేసుకుంటారు మేడం. సో కంటిన్యూ అయిపోద్ది, ఈజీగా ఉంటుంది.
Your
Tomorrow
Lordship,
itself.
Your Lordship, item number 246 and 247, Your Lordship, coming for extension of interim orders.
415 తీసుకుందరమ్మా, 415 తీసుకుందరు ఇష్యూ కానీ. Now that now this list now is stopped here, probably I'll resume the other work and will continue, no problem.
So blessed, Your Lordship.
కౌన్సిల్స్ పేరు మొత్తం రాసి మొత్తం అంతా కూడా ఎట్ సీనా కుమార్, ప్రమోద్ అండ్ శ్రీనివాస్, హరికృష్ణ అందరూ మొత్తానికి అందరం పెట్టండి ఫర్ కంటిన్యూషన్ టుమారో.